This is Bloomberg Law with June Grasso from Bloomberg Radio.
Donald Trump once vowed to take the witness stand in his hush-money criminal trial in Manhattan. But his defense case wrapped up this morning without jurors hearing from the former president, although he did speak to reporters outside the courtroom.
We have a phenomenal case. We've won the case by any standard. Any other judge would have thrown this case out. Any other judge would have thrown this case out.
Judge Juan Merchan sent the jury home for a week, setting closing arguments for next Tuesday. But the attorneys returned to the courtroom in the afternoon to discuss jury instructions, a sort of roadmap meant to help jurors apply the law to the evidence and testimony. It's a standard part of the process that's taken on greater importance because of the unusual nature of the 34 false records charges against Trump. To make each crime a felony rather than a misdemeanor, jurors must find that Trump intended to commit another crime. Much of the debate centered on how the judge will explain those other alleged crimes, including election law violations and tax crimes. Joining me is Bloomberg legal reporter David Voreacos, who's covering the trial. David, the second and final defense witness, Robert Costello, was back on the stand. What did the defense hope to get from his testimony?
The defense called Robert Costello because they wanted to undermine Michael Cohen as a witness. This has been a big theme of the defense, that Michael Cohen is a liar and can't be trusted, and that he had also lied on the witness stand in this trial as well as in previous testimony under oath in Congress and in court. What the defense wanted to show was that Cohen could not be trusted when he said that Costello came to him in April of 2018 after the FBI had raided Cohen's house, office, and hotel suite, and that Costello offered a back channel to President Trump. Cohen testified at some length about how Costello tried to offer comfort to Cohen that Trump had his back, and Cohen testified that he believed that that was just so that he would stay in the fold and not cooperate against Trump in the criminal investigation that federal prosecutors were conducting at the time.
And what happened on the stand? There was a kerfuffle? I don't know how to describe it.
There was a major kerfuffle in court at the end of the day on Monday. Costello came to the stand late in the day, and he began to refute several of the points that Michael Cohen had made in his testimony. And he essentially started giving long soliloquies in his answers, which is not proper behavior for a witness. They're supposed to listen to the question and answer the question that's asked and not go off on a long tirade or rant or soliloquy, which is what Costello was doing yesterday. And so the judge sustained a number of objections. And then at some point, Costello said, geez, when the judge sustained an objection, and the judge said, I'm sorry. And then Costello said, stricken, referring to his own remark. And after a couple more questions, Merchant stopped the proceedings and he asked the jury to leave. And he said to Costello, Mr. Costello, I want to discuss proper decorum in my courtroom. If you don't like my ruling, you don't say, geez, and then you don't say, strike it, because I'm the only one who can strike testimony in my courtroom. He also threatened to hold Costello in contempt, and the judge cleared the courtroom, basically removing dozens of journalists for several minutes. They then came back in and saw a more subdued Costello finish his testimony. So it was a dramatic moment. It's not entirely clear how it might affect the case, if at all, but it certainly did not help the defense case because they saw Costello as someone who was going to further erode the credibility of Michael Cohen in the eyes of the jury.
So, David, do you know what made the judge clear the courtroom? I've never seen a courtroom cleared.
It's not entirely clear. I was in the overflow room and watching by video hookup, and people in the courtroom didn't really understand. Reporters objected, and I believe there was a lawyer who tried to speak up on behalf of the media. But The judge just didn't allow it. It was clear that the judge was quite visibly angry, and he felt that Costello was openly defying him. And so I think he wanted a moment to really let his anger out with Costello. Not entirely clear why he felt the need to clear the courtroom, but at least it didn't happen for very long.
Do you have a transcript of what happened while he cleared the courtroom?
I do, and that's when the judge threatened to cite him for contempt. That only went on for a brief exchange. A lot of the transcript reflects sort of the chaos of people objecting in the gallery to being ejected and the courtroom staff trying to clear the gallery.
Did the prosecution do a good job of crossing Costello?
The prosecution did a very effective job of showing that Costello's interests seemed to be aligned more with Trump than they were with Michael Cohen in the spring of 2018. Cohen's lawyers had argued and Costello had testified that Costello was looking out for Michael Cohen when Michael Cohen was very concerned that he would be prosecuted, and he was exploring the possibility of whether he should cooperate or not against Trump. Trump and his supporters were obviously very concerned about that, and Cohen had testified, and the prosecution has argued essentially that Costello was not looking out for Cohen. What he was really looking out for was trying to get information about Cohen and his intentions that would help Trump in his defense. And the prosecution today on cross-examination showed a number of emails from Robert Costello that it suggested indeed his interests were with Donald Trump.
Now, who was the first witness that the defense called?
The first witness was a paralegal who works with Todd Blanche, who's the lead defense lawyer. And he put up a summary chart of phone calls and communications between Michael Cohen and Todd Blanche and his law firm. They were trying to show that there were a great many communications, and Costello had also testified that he believed they had an attorney-client relationship, which Michael Cohen said they did not, that he never hired Bob Costello and he didn't trust him.
I thought they were going to call an expert witness on campaign finance laws.
They had talked to the judge at some length yesterday about the ground rules for how they might question an expert witness on campaign finance law, and the judge essentially listened closely to the objections of prosecutors who felt it would be unfair for a defense campaign finance expert to go into too much detail on the law, and the judge agreed, saying essentially that he's the only one who can tell the jury what the law is when it comes to campaign finance and how it relates to this case. And the judge said he didn't want this to become a so-called battle of the experts, where the prosecution had to also call their own experts to refute whatever the defense experts said. And so he set some very strict guidelines on what a defense expert could say, and after considering those strict guidelines, the defense elected not to call their expert.
Did the judge instruct Trump about the waiver of his right to testify?
Surprisingly, the judge did not do that, and it was very muted and almost anticlimactic. Todd Blanche just said, "Your Honor, the defense rests." There was no discussion with Trump, and that was it. Then the judge, shortly after that, told the jury that he was dismissing them until next Tuesday, May 28th, because there had already been prearranged days off on Wednesday and Friday of this week, and of course Monday is Memorial Day. So the judge also wanted to have continuity in the closing argument, so I guess he was concerned that they wouldn't be able to get both closing arguments in one day. So he said that it's possible that the closing arguments may spill over next Tuesday into Wednesday, when he expects that deliberations will begin in the case.
Has he set any time limits for the closing arguments?
He has not set limits yet. He expressed that he knew that there was a lot to go over and that they would take some time, but he has not set a specific length just yet. I assume that as we get close to the date, he will do that.
Jury instructions are critical. Tell us about the charging conference on Tuesday afternoon.
The judge is expecting to work out how they will instruct the jury about applying the law in this case. And what's complicated is how the election law applies to this case, because the 34 falsification of business record counts that Donald Trump faces are misdemeanors unless they're in furtherance of another crime. And the other crime, prosecutors say, is trying to influence the election illegally in 2016. And so there's a lot of complicated case law on this question, and both sides need to make their best case to the judge, who will then make a decision on how to instruct the jury on the law when it relates to the election in 2016. I'd also say that I'd imagine if Trump were convicted, the jury instruction on election law could be an area of appeal for him.
Has the prosecution said whether it's federal election law or state election law that's concerned here?
In the filings and in arguments, they've discussed both. That's why I'm going to be watching closely to see what they end up at. I believe it's some combination of state and federal law.
So there could be a verdict in this case next week. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. Coming up next on the Bloomberg Law Show, what an arrest warrant from the International Criminal Court would mean for Netanyahu. I'm June Grasso, and you're listening to Bloomberg. The chief prosecutor for the International Criminal Court is seeking arrest warrants for Israeli Prime Minister Benjamin Netanyahu and Hamas leader Yahya Sinwar for war crimes related to the Israeli military response in Gaza and the Hamas militant group's October 7th attack on Israel. Prosecutor Karim Khan said the charges against Netanyahu included crimes against humanity.
The crimes include starvation of civilians as a method of warfare, willfully causing great suffering, serious injury to body or health or cruel treatment, willful killing or murder, and intentionally directing attacks against a civilian population.
Netanyahu called the move a moral outrage of historic proportions.
He is attacking the one and only Jewish state and trying to handcuff us, preventing us from exercising responsibly through the laws of war as we obey them and we are subordinate to them. He's saying we're not. He's creating false symmetry, false facts.
Joining me is Kate Mackintosh, UCLA law professor and director of the Promise Institute for Human Rights. Explain the charges for us.
The accusations fall into two different categories, obviously. So as far as the Hamas leaders are concerned, the focus is, of course, on the hostage-taking and the extermination and murder that was committed on October the 7th, and the treatment of the hostages, or rather the mistreatment of the hostages since then. And the prosecutor has characterised those acts as both war crimes and crimes against humanity, which means to say part of a widespread or systematic attack on the civilian population. So those are two different crimes under their own statute. There's war crimes, violations of the laws of war, and then crimes against humanity, which don't have to be committed in an armed conflict, but which can be. Looking at the charges against Netanyahu and Gallant, these fall mainly into two categories. One is crimes around the placing of Gaza effectively under siege, so the denial of access to humanitarian assistance, what he characterises as starvation of civilians as a method of warfare, so the sieging of Gaza. And then the other main crime that they're charged with is intentionally directing attacks against the civilian population, which is a war crime. Under laws of war, of course, it's only permitted to target military objectives, not to target civilians. And Karim Khan is charging Netanyahu and Gallant with having intentionally attacked civilians.
The panel was unanimous. What's the standard? Is the standard reasonable grounds to believe?
Yeah, it's a relatively low standard at this point. There are actually three different points during the process of a case where the evidence is tested against an accused. So this is just the first one in order to issue the arrest warrant. And the judges who look at this application have to be satisfied that there are reasonable grounds to believe that the crimes have been committed. They don't test any evidence, and even some of the evidence can be provided in summary. What it really means is that the judges will look at each element of the crime and they'll see whether there is evidentiary support of each of those elements. So the finding they're really making is if all of this evidence stands up, then the crime has been committed. So it's a relatively low threshold. I'd be very surprised if the prosecutor fails in this request, because I can't imagine that he would have presented an inadequate submission for something so high profile. And he's also asked this panel of experts to kind of confirm that he's on solid ground here. So that, combined with the fact that the test is a fairly low bar, I think means that we're likely to see the trial chamber granting his request for the arrest warrant.
So just to be clear, the prosecutor at this point is requesting a warrant, and then it will go to a court panel to decide whether or not to issue the warrant?
Yeah, exactly. It goes to what the ICC calls a pre-trial chamber. It will be 3 judges who are put together to consider a range of requests that come up before the trial actually starts. And they will be the ones who will be looking to see if all the elements of the crimes have been substantiated by the material that he's put before them. Just, by way of explaining what then goes on to happen with the evidence, before the trial happens, there's another procedure, which is the confirmation of the charges. And that is, of course, still not a trial, but it's a higher standard. So at that point, the judges will have to consider, again, a pre-trial chamber of judges, will have to consider whether there are substantial grounds for believing that the crimes have been committed. So we've gone from reasonable grounds up to substantial grounds. And at that point, the accused can object, can challenge the evidence, and can present his or her own evidence as well. So it's not a trial, but it is a kind of higher threshold where the evidence is tested to some certain account. And if the prosecutor manages to cross that threshold, then the trial could go ahead.
Israel is not a member of the ICC. Let's say the
Correct.
arrest warrant is issued. What does it really mean for Netanyahu?
I mean, the fact that Israel is not a member of the ICC, so it's not relevant to the jurisdiction over Netanyahu just because the crimes were committed on the territory, a territory which is subject to the jurisdiction. So the ICC, as you know, has accepted Palestine as a member state of the ICC. They were very careful to say that they were just deciding in terms of ICC membership and not making any bigger statements about whether there's a state of Palestine. But that means that any acts committed on the territory of a state party to the statute is subject to the jurisdiction, of course. So, any state can delegate its jurisdiction to a court. So that's what Palestine has done. So that's how they are permitted to charge Netanyahu and Gallant, even though, of course, their nationality as Israelis would normally place them outside the jurisdiction of the court because Israel isn't part of the system. Practically, though, and I think that's more what you're getting at, there is an issue about how the court is going to get their hands on them, right? Because, for a start, they are sitting, Prime Minister and Minister of Defence. So they're obviously not going to hand themselves over. Even if Israel was a state party, there'd be an interesting situation there. But more to the point, Israel is not under any obligation to comply with an order of the court. So it's more an issue for travel for Netanyahu and Gallant. If the arrest warrant is granted, and as I said, I think we can be fairly confident that it will be, that's going to be very interesting because travel to a member state of the ICC should mean that state will arrest them, will execute the warrant. So that could be problematic.
Because last year, and I believe we talked at that time, Russian President Vladimir Putin, the court issued a warrant for him for abductions of children, and nothing's happened there.
Exactly. So that would be exactly an analogous situation, yes.
Let's talk about this internally in Israel and internationally. So as far as Israel goes, has this backfired because it seems as if it's cemented support for Netanyahu at home, including 2 members of his cabinet who threatened to resign in recent days if he didn't have a clear post-war vision for Gaza. So has it backfired in that sense, at least in Israel?
Possibly. It's hard to know, isn't it? I think, it may have done. On the other hand, I suppose that, there may also be segments of Israeli society who feel that it's a stigma that they're very unhappy about, and it might encourage opposition to Netanyahu. I think it's important to remember that is not a calculation that the ICC prosecutor is supposed to be making. The ICC prosecutor is not meant to be calculating what the political implications of his indictments or his request for arrest warrants are. He's been given authorization to open an investigation. He's meant to conduct his investigation, and where he finds evidence of crimes committed in the statute, he's supposed to request an arrest warrant, as is done. So the political ramifications are hard to say which way they're going. I mean, I wouldn't be surprised if it creates some kind of solidarity in Israel. I think we can all kind of imagine that is a somewhat natural reaction, but that isn't really something that Karim Khan should be thinking about.
Internationally, Netanyahu already has a troubled reputation. Internationally, does this add a little more of a blemish to his name?
Oh, for sure. I mean, apart from anything else, any sort of head of state meetings that are held in a state that's party to the ICC, I mean, they wouldn't really be able to invite Netanyahu. And so we're talking about pretty much the whole of Europe, Latin America, Africa. There are 124 states parties to the ICC, including some very powerful states on the global stage. So he will already become somewhat of a pariah in those circumstances, because no state, frankly, wants to be in the position of having to arrest him and hand him over to the court. So I think they would be very likely to just discourage him from travelling to their territory.
What are the powers of the International Criminal Court?
In terms of sort of outside its own walls, the powers are entirely dependent on other states. So it doesn't, of course, have some kind of international police force that it can send out to arrest people. It can't enforce its orders. It is a creation of states. So the states that have signed up to its statute, the states that run the court, I mean, the member states of the International Criminal Court meet every year in December in either New York or The Hague to discuss how to run the court. They, of course, don't interfere with the legal proceedings and the work of the judges and the prosecutor, but they decide, how much money to give it. They can amend the statute and so on. So those are the states who are also responsible for enforcing the orders of the court. So that's why a state in whose territory any of the, either the Hamas or the Israeli indictees arrived would be bound to execute that order, I mean, if it's granted, the arrest warrant, and hand them over to the court, because the court itself doesn't have any enforcement powers independent of the states.
What was the last leader that they've prosecuted, actually, held a trial for?
Well, the last sitting, there is a precedent of having prosecuted a sitting head of state, which did not go well, and that was Kenyatta in Kenya. I mean, that prosecution ended essentially, very poorly, and what became clear was that it was almost impossible. I mean, it was an unsuccessful prosecution. It became clear that it was almost impossible to prosecute or to effectively investigate a sitting head of state in the country. So there were all sorts of allegations of witness intimidation. I believe, some of those were established, if I'm not misspeaking. I think one witness died in very mysterious circumstances, and the case was eventually dropped. So, I mean, that was really a case of prosecuting a leader that came up against, realpolitik, and realizing that when somebody is still wielding the power of the state, it's extremely difficult for something like the International Criminal Court, which, as I said, relies on states for enforcement of its orders and to work effectively to carry out its mandate.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with UCLA law professor Kate Mackintosh, and we'll talk about President Joe Biden's response to the ICC seeking an arrest warrant for Netanyahu.
Contrary to allegations against Israel made by the International Court of Justice, what's happening is not genocide. We reject that.
President Joe Biden has defended Israel and railed against the International Criminal Court's prosecutor, who's seeking arrest warrants for Israeli Prime Minister Benjamin Netanyahu on war crimes charges. Prosecutor Karim Khan is also seeking an arrest warrant against the Hamas leader on war crimes charges. And Biden said that whatever this prosecutor might imply, there's no equivalence, none, between Israel and Hamas. And he refused to agree with any notion that the war in Gaza is genocide. I've been talking to Kate Mackintosh, a professor at UCLA Law School and director of the Promise Institute for Human Rights. Actually, the objection from Biden, part of it, was equating Israel's actions and Hamas's action. And I mean, is it wise? It seems like, it's Solomon splitting the baby.
I think it was his only option, actually. I don't think he could possibly have proceeded against only one party here. I mean, in a way, the law that he's applying does parties to a conflict on a somewhat equal footing. So the laws of war are not concerned with the reason for fighting. So any of the justifications that either side has, whether it's the occupation and the oppression of Palestinians or, the existential threat coming from Hamas and the hostage taking, those are completely irrelevant in assessing whether the laws of war have been followed. The international humanitarian law, the laws of war, Geneva Convention are about the rules once you're in a conflict. And at that point, a state or, the groups are seen only as either state or non-state actors. There's no characterization of good or bad or terrorist or whatever. And, rules apply to both. And what the prosecutor has done is he's applied those rules to the facts and he's found violations on both sides, which I think we could anticipate would have been the case from what we've all seen covered in the news. So in a way, the framework he's working with, it does apply to all sides, and it almost does put them not on an equal footing, but it makes irrelevant their motivations for fighting, the historical context, whether they see themselves as taking part in a just war, whether they're a state actor or a non-state actor. It just looks at these are the rules and how have they been violated. And if he were to apply those only to one party, I think it would be, totally unacceptable and look extremely biased.
Back in 2020, when Trump was president, he authorized economic and travel sanctions on the ICC prosecutor and another senior prosecutor because they were looking into possible war crimes in Afghanistan. Has it always been an uphill battle for the ICC?
Well, only when the US is concerned. I mean, yeah, we were all so shocked when that happened. And then some of President Biden's rhetoric has seemed to be almost going in the same direction, which is, perhaps a bit disappointing. Listen, the ICC is never going to make people happy. There's less of a fuss when the ICC is prosecuting somebody from the Democratic Republic of Congo because the individuals in the Democratic Republic of Congo do not have the powerful friends that Benjamin Netanyahu does. But, it's never going to be, it's an enforcement activity. To arrest someone from an international crime is clearly going to make ripples. And I think the prosecutor has to be prepared for that.
Netanyahu has been compared to a phoenix rising from the ashes. Nothing seems to affect him. He keeps on going and going. Will this be any different, do you think? He's been doing interview after interview defending his actions and equating an attack on him as an attack on Israel.
Who knows? It's very hard to say. I think it is going to affect his international standing. I don't know how it's going to play out domestically. What we saw in the case of Slobodan Milosevic, for example, so another leader that was indicted for international crimes, this time not by the International Criminal Court, but by the Yugoslavia War Crimes Tribunal. He was indicted. I think that probably facilitated his removal from power, and then he was handed over eventually to the tribunal. So we have also seen that precedent. As I said, who knows how it's going to play out for Netanyahu. Yeah, how's it going to play out for Putin? I think there's some similarities there. They're both strong leaders who seem to be clinging to power. It's hard to tell. Of course, in Israel, it's a lot easier to understand the opposition because of the democratic nature of the country, and we've seen the demonstrations and we could read the free press. That isn't the case in Russia. But I would say the situation for both of those leaders will become more tricky when they're no longer heads of state.
And tell us about the International Court of Justice, where South Africa is making a genocide case against Israel.
At the International Court of Justice, the World Court in The Hague, so the non-criminal court. So South Africa brought a complaint against Israel under the Genocide Convention. So that's the International Court of Justice. That operates, you can imagine it much more like a sort of civil proceedings in a domestic court. So it's more like a country suing another country. It's not an independent authority, telling anybody that they've broken the law. It's about disputes between states. So it can be all sorts of things. It can be a border dispute or, you've dammed my river and I haven't got the same water supply I used to have. but it also has jurisdiction, it can look at all international laws. And what South Africa said essentially to the court was, we're all parties to the Genocide Convention. Israel's a party, of course. South Africa's a party. And Israel has broken its commitment under the Genocide Convention not to commit genocide. And so as I'm party to the Genocide Convention, and as we all have an interest in genocide not being committed, I'm going to complain about it. And what I'm going to ask you to do, International Court of Justice, is to tell Israel to stop committing genocide. So the court, it was an emergency hearing, so it happened very fast. Usually proceedings at that court are extremely slow, take years. But this was a preliminary, what's called a provisional measures hearing, a bit like an injunction in a domestic court. So it went fast. South Africa presented its case to the court. What that meant was it gave it an opportunity to recite, the horrific information that had been coming out, particularly of UN bodies. I think they only cited United Nations sources. They were very careful in their, what information they used. But it gave them the opportunity to recite all this horrific evidence about the suffering of people in Gaza in this very hallowed, esteemed international body in front of all the judges of the International Court of Justice, which I think was already a very important symbolic step. And then the judges basically said, it was a provisional ruling, so they didn't say genocide's been committed. They weren't actually being asked to decide that at that stage. The case is now ongoing. But they were asked to see whether there was a plausible case, essentially, that genocide was being committed. It's a little bit more complicated. It's actually a plausible case that the right of South Africa, to have genocide not committed was being violated. But anyway, it's been sort of translated slightly too easily into saying that it was plausible that genocide was being committed. It wasn't quite that. But anyway, they said that threshold had been met. And so they did make an order, and they did note the evidence that had been put before them about humanitarian assistance and targeting of civilians and so on. And so they said to Israel, please not only do not commit genocide, but stop any incitement to genocide, because some of the material South Africa had put before the court were these statements about human animals and, these sort of genocide-sounding statements that different individuals in the government and military had made. So they said to Israel, you're obliged under the convention not to commit genocide, to make sure nobody under your control does so, and to stop incitement to genocide. And also you have to allow humanitarian assistance through to the Palestinians. So they made that order. The International Court made that order to the state of Israel. So that wasn't singling out the individuals that the International Criminal Court has singled out. That was looking at the whole state apparatus and telling them to respect their obligations under the Genocide Convention, essentially.
As far as the ICC, they can't try Netanyahu in absentia, can they?
They can't. No, they can't.
Do you have any final thoughts as an international lawyer?
As an international lawyer, an international criminal lawyer, this is quite unremarkable. I mean, it looks solid. It looks like he's obviously been doing the investigation. He even mentions in the press release what kind of materials he submitted. So he talks about interviews with witnesses, but he also talks about, photographic evidence and satellite photos and expert witnesses and so on. He seems to have taken the crimes that seem most obvious, that would be the easiest to establish, which makes sense because he wants a conviction. I think the denial of humanitarian assistance, the whole starvation issue, which we're reading about horrifically, as well as the targeting civilians, makes sense. I think the crimes that Hamas has been charged with around the hostage taking also makes sense. So it's caused a big political storm, but really from a purely legal point of view, it looks pretty reasonable.
Thanks so much for your time, Kate. That's Kate Mackintosh, a professor at UCLA Law School and director of the Promise Institute for Human Rights. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.